There is no crime more serious than murder. There is no punishment more final than death. And there is no mistake more irreversible than executing an innocent person. Welcome back to the Verdict Room. I'm your host, and today we're examining 5 cases that have fundamentally changed how America thinks about the death penalty. These aren't abstract legal debates. These are stories of real people who came terrifyingly close to, or in some cases did, lose their lives for crimes they did not commit. Let's start with a question that haunts the American justice system. How many innocent people have been executed in this country? The honest answer is that we don't know. But the cases we're about to examine suggest the number is not 0. And that possibility alone should make every American pause. Our first case takes us to Alabama in 1985. A man named Anthony Ray Hinton was arrested for 2 murders he did not commit. He would spend the next 30 years on death row. Anthony Ray Hinton grew up in Alabama during the height of racial tension. He was a quiet man, a mechanic, someone who kept to himself. In 1985, 2 restaurants were robbed and their managers killed. Police zeroed in on Hinton almost immediately. Why? He was black, he matched a vague description, and he was poor enough that he couldn't afford a competent defense. The prosecution's case rested on one thing: ballistics evidence. They claimed that a revolver found at Hinton's home fired the bullets that killed the victims. The problem was that ballistics experts at the time used subjective analysis, looking at bullet markings under a microscope and making judgment calls. There was no objective, scientific standard. 2 experts could look at the same bullet and reach opposite conclusions. Hinton's trial lawyer was woefully unprepared. He didn't hire his own ballistics expert to challenge the state's evidence. In fact, the lawyer was so ill-equipped that he later admitted he was sleeping during parts of the trial. In 1986, an all-white jury found Hinton guilty. The judge sentenced him to death. But here's where the story takes a turn. Decades later, in 2014, a lawyer named Brian Stevenson took on Hinton's case. Stevenson is the founder of the Equal Justice Initiative, an organization dedicated to defending the wrongly condemned. He brought in modern ballistics experts, real scientists, not subjective guesswork artists. These experts examined the same revolver and the same bullets, and they concluded what should have been obvious from the start. The revolver could not have fired those bullets. The striations, the microscopic marks that are unique to each gun, simply did not match. In April 2015, after 30 years on death row, Anthony Ray Hinton was released. He had spent 3 decades awaiting execution for a crime he did not commit. He was exonerated. Today he travels the country speaking about his experience. He has met with victims' families. He has become an unlikely voice of compassion in a system that nearly killed him. But Hinton's case, as shocking as it is not unique. It represents a pattern. Our second case forces us to confront something even more disturbing: false confessions. In 1989, a jogger was brutally assaulted in Central Park in New York City. A woman in her late 20s was raped and nearly killed. The crime horrified the nation. Within days, police arrested 5 teenagers. They ranged in age from 14 to 16 years old. These were kids. And here's what happened next. After hours of interrogation, without parents present, without lawyers, 4 of the 5 confessed, on camera. Detailed confessions that seemed to corroborate the violent crime. The confessions were so convincing that the prosecution, the jury, the public, everyone believed these kids were guilty. In 1990, they were convicted. They were sentenced to prison sentences ranging from 5 to 15 years. But in 2002, 13 years later, DNA evidence re-examined the case. A man named Matias Reyes, already in prison for other crimes, confessed to the assault. The DNA matched Reyes. It did not match any of the 5 teenagers. The Central Park 5, as they came to be known, were exonerated. Their convictions were overturned. They had lost over a decade of their lives in prison for a crime they did not commit. And the psychological mechanism that put them there, police interrogation techniques that are known to create false confessions in innocent people, especially minors whose brains are still developing and who are more suggestible. How does an innocent person confess to a crime they didn't commit? Through a combination of factors: isolation, fatigue, the psychological weight of authority figures, the false evidence presented by police, and sometimes, in the case of juveniles, the inability to think through long-term consequences. Modern interrogation research shows that innocent people can be convinced, after hours of questioning, that they actually did commit a crime. It's called a false confession, and it happens more often than most people realize. But there's something worse than a false confession. There's a false confession that leads to execution. Our third case involves a man named Henry Lee McCollum. In 1983, an 11-year-old girl was found dead in Robeson County, North Carolina. She had been raped and murdered. Police focused on McCollum and his half-brother Leon Brown. Both men were intellectually disabled. Both were African American. Police interrogated McCollum for hours. Under intense pressure, with no lawyer present, McCollum confessed. His confession was remarkably detailed about the crime. He even drew a map of the crime scene. Based largely on his confession, both men were convicted. Both were sentenced to death. For 33 years, McCollum sat on death row. 33 years. In 2014, the Innocence Project, an organization dedicated to exonerating wrongly convicted individuals through DNA testing, took on his case. They obtained DNA evidence from the crime scene and tested it. The results were unambiguous. The DNA did not match Henry Lee McCollum. It did not match Leon Brown. It matched an unknown male. In 2014, McCollum was exonerated. He had spent 3 decades on death row for a murder committed by someone else. The confession he had given decades earlier was false, a product of interrogation pressure, his intellectual disability, and a justice system that failed him. McCollum's exoneration raises an urgent question. How many innocent people are still on death row right now? How many confessions in case files are actually false confessions from vulnerable people? In 2004, a law professor named Brandon Garrett published a groundbreaking study. He examined 125 DNA exonerations, people who had been convicted and then exonerated through DNA evidence. His findings were devastating. 25% of those exonerations involved a false confession. 1 in 4 innocent people convicted had confessed to a crime they didn't commit. 24% involved misidentification by eyewitnesses. 14% involved official misconduct. 80% involved some form of unreliable evidence. A confession, a mistaken identification, forensic evidence that wasn't scientifically sound. Garrett's research, updated repeatedly over the years, has become the foundation for understanding how innocent people get convicted. It's not usually one massive error. It's usually a cascade of smaller failures. A false confession, weak eyewitness testimony, inadequate legal representation, and confirmation bias, where police and prosecutors focus on evidence that confirms their theory and ignore everything else. Now let's bring this to 2026. Where do we stand on the death penalty in America? As of 2026, the death penalty landscape is shifting. Illinois abolished capital punishment in 2011. Virginia, the state that has executed more people than any other in American history, abolished it in 2021. The number of death sentences imposed each year has plummeted. In 2022, there were only 18 death sentences imposed nationwide, the lowest number in decades. But capital punishment remains on the books in 27 states. And this year, 2026, we've seen renewed debates around wrongful conviction claims and post-conviction relief. Georgia, for example, passed a new law allowing judges to award significant damages in wrongful conviction cases. These cases are no longer theoretical. The central question remains, can we execute people in a system this fallible? We know that innocent people confess to crimes. We know that eyewitnesses are unreliable. We know that forensic evidence can be interpreted subjectively. We know that poor defendants receive worse representation than wealthy ones. And we know that execution is irreversible. There's another layer to this that we haven't fully discussed: racial disparity. African Americans make up approximately 13% of the US population, but represent about 42% of death row inmates. This disparity reflects not just different crime rates, but systemic bias in how cases are prosecuted, how juries are selected, and how evidence is presented. The Innocence Project's data shows that exonerations are not evenly distributed. African American defendants are exonerated at higher rates, suggesting they were more likely to be wrongly convicted in the first place. The cases we've examined today, Hinton, the Central Park Five, McCollum, are not outliers. They represent structural problems in our criminal justice system. They represent moments where the system failed spectacularly. But here's what's important. They also represent moments where the system corrected itself. Through decades of legal appeals, through dedicated lawyers, through DNA evidence, through organizations like the Innocence Project, these men were freed. But that correction took 30 years in Hinton's case, 13 years in the Central Park Five case, 33 years in McCollum's case. How many innocent people don't have dedicated lawyers? How many cases never get DNA testing? How many innocent people are executed and never exonerated because the evidence is destroyed or the body is buried? That's the question that defines the death penalty debate in 2026. Here at the verdict room, we believe the law should protect human life, all human life. That includes the lives of victims whose murders demand justice. And it includes the lives of defendants who deserve a fair trial, competent representation, and the presumption of innocence. When those principles fail, when innocent people are convicted and executed, we have not achieved justice. We have committed murder with the state's stamp of approval. The cases we've examined today should make every American think hard about the death penalty. Think about what justice really means. Think about whether any system, no matter how carefully designed, can be trusted with the power to take human life. If this video has made you think, if it sparked a question about justice, about the law, about how we should handle the most serious crimes, then we've done our job. Subscribe to the Verdict Room for more deep dives into cases that matter. And in the comments below, tell us, do you believe the death penalty can ever be fairly administered? What would justice look like for you? Thanks for joining us in the Verdict Room. We'll see you next time.